Welcome back to the courtroom. And trust me, today's session is loaded. From a desperate defendant begging for leniency to another outright challenging his own lawyer in open court. It's drama, confusion, and confrontation all rolled into one. Judge Simpson is calm but commanding, balancing fairness with firmness. But as emotions rise, the truth about accountability, second chances, and personal responsibility starts to unfold. Will these defendants seize their last shot? Or sabotage their own defense? Let's dive in and find out.
Set for tomorrow.
Pardon?
His interview date is set for tomorrow.
So he's going to be interviewed
He's
tomorrow?
going to be interviewed tomorrow.
All right. So will they get an answer within a week?
I assume he'll get an answer really quick.
Okay. So I'll adjourn it out one more week to the 29th.
Period.
June 29th, 2025, 9 a.m. Bond continued.
Thank you, Ron.
Thank you.
Excuse me. I would like to waive my circuit court. Thank you.
You want to waive your preliminary examination?
That's right.
And
Have you talked to your attorney about that?
Matter if I could approach with counsel.
Yes. Washington, you want to waive your preliminary examination. Your counsel's asking that I adjourn the probable cause conference. Certainly you have the right to waive it. But usually people do that in consulting with their attorney. Okay. Now, just listen closely to me. My understanding is that there is the possibility of working this thing out in a way where there may not be a felony for you.
A what?
Okay.
Pardon me?
Did you hear me or no?
No, I didn't.
That there may not be a felony.
I understand.
Okay. So that may not happen if you waive. Okay.
Right.
So here's what I'm going to do. I'm not saying no to what your request is. Okay. What I'm going to do is I'm going to put it over a week, let that process happen. If it doesn't work out or whatever happens, then we can do the waiver next week.
Right.
Fair enough?
I'm actually going to be no, we just waive it. One of them.
Your Honor, he's asking for a PR. I mean, I don't know if the court would allow him to get the interview conducted tomorrow.
Once I get an answer from hang on a second, Mr. Washington, you got to listen to me now.
Yes, sir.
Okay. So once I get an answer from that, I'll consider release on a PR. Okay. I'm not saying that I will, but once he does the interview and I get some information from that, then I'll consider doing something.
With all due
Okay?
respect,
But-
Your Honor, I was supposed to had this business taken care of with this young man.
This what?
Would you explain to him I was supposed to had this taken care of? Please send me.
No, he's explained that to me.
Okay.
I understand that.
Well,
It's not.
I just rather let it go through, let it play the role, because I'm not gonna keep coming in here every week going through this. I'm saying $174, good Lord. Y'all letting people out with worse things than that. You know, it's been a month. Forgive me. I was homeless. I missed court. My father's in the hospital. I'm a working man. If you check my check record, my ground record, I don't go to jail.
Mr. Washington, I usually don't adjourn a week out. I usually go in 2-week intervals.
I know I've
I'm
been
trying to get you before the court as quickly as I possibly
right,
can.
but I've been back,
Yeah.
sir,
Yeah.
with all due respect, a month. You know, I'd be a fool not to show back up in court in front of Judge Simpson anyway. You know, I'd be a damn fool if you let me go not to show back up. But
That's probably accurate.
right,
So-
you know, with all due respect,
No.
right?
You can feel the frustration building here. Mr. Washington's trying to convince the court he's not a flight risk, emphasizing his work, family, and the fact that he showed up despite being homeless and dealing with personal hardship. It's emotional, it's raw. But judges often have to separate empathy from evidence. The key takeaway? Sincerity doesn't always equal strategy. Even a heartfelt speech might not sway the court if the paperwork, timing, or prior record says otherwise. Still, you have to respect the honesty here. What do you think? Is he making a strong case or talking himself deeper into trouble?
But
That was a heap of respect.
right. I'm just saying,
I'm good.
you know, my father is ill right now.
Mr. Washington, okay. I know you may want me to do it a different way, but you also know me well enough to know
Well, I
I'm
don't.
gonna do it my way.
Well,
I'm gonna hear everybody out, and this is the way I'm gonna do it. So I'll see you next week. If at that point the stuff that's supposed to happen doesn't happen, then I'm gonna deal with that. I'll let you waive. I'll let you do whatever you need to do. But I don't want you in a circumstance where you might be hurting yourself. If something worked out that's going to be beneficial for you, then let's get it worked out and let's get this thing moving. All right. Thank you. His bond will continue.
Thank you, Your Honor.
Court calls the case people versus Montel Gatlin. Shaquila's back there all. She's like, why you call me out like that? The prosecutor say something.
No. Sorry, just another picture. Assistant Public Defender Chelsea Vergils with and on behalf of Montel Gatlin, please state your name.
My name is Montel Gatlin.
Thank you. What are we doing?
Your Honor, we are asking to set the preliminary exam in both of these cases. We do not have discovery in one case. I informed my client of that. He does not wish to waive the 21-day timeline in these cases. He asks to set preliminary exam regardless of knowing we don't have discovery in one case.
Which, yeah,
I mean, may I speak?
if you want.
I kind of don't. I don't want her to represent me
Okay, so you don't get that choice necessarily, but why?
because just conflict. Like we had a back and forth back there in the back room. Like I don't think she has my best interest.
Really?
Yes.
Why? Because she wouldn't do it you?
Huh?
What? Because why do you say that? Because I've never known Mr. Deals not to have her client's best interest at heart. Ever.
By the things she said, this
A lot of things that she said you may have disagreed with, right?
really all things.
Okay, all she said. Sometimes that's a lawyer's job. Sometimes they have to give their client the hard facts of what's going on. And they have to do that they have to give them their legal interpretation of what's going on, which may not suit with what you want to happen in the world. But they just give you a steady dose of reality. So if you disagree with her legal analysis, then fine, but show me your law degree.
No, I'm disagreeing with her legal advice.
Okay, and you're doing that with your legal degree that you have, right?
No, she was.
Yeah, that's what I thought.
No, I don't have a legal degree, but
I
she was
know.
trying to get me to waive things. And like I was telling her, it would kind of waive my rights to 180 days into trial, right?
She
And-
just got before me. Did you even listen to what she said? She has indicated that you don't want to waive any statutory period. So she listened to what you said. She told me that, and I was going to set these for exam. Anything else?
Yeah, I don't want her in my case.
Well, she's on your case.
Your Honor, I would ask to also address bond if possible.
Yes, you may. Hang on a second. Let me set the exams in these cases. And which case don't you have discovery on that he's trying to set it before you guys get a chance to even look at it? That makes so much sense, but go
We're
ahead.
missing media discovery on 25 FB 1090.
On 1090?
Yes, Your Honor.
All right. Discovery on that one is not complete. I'm going to note that. Do people have their witnesses available on the 3rd? Pardon? All right. Preliminary examination in these matters will be set June 3rd, 2025. 9 a.m. That's before me, right? But there's both come before me. They're in person. That's the bond.
Your Honor, we're asking the court to consider lowering the bond on case 25 FB 1142. Currently, it's set at $50,000. He's asking you to lower it to the same amount as his other case, 10%. Mr. Gatlin is an Ypsilanti resident. He is employed as a plumber. He at least was before he was in custody and plans to go back to that work. He's involved with his church. He plans to abide by his bond conditions. At this time, he's been in custody for 11 days now, and he is being held until May 29th on a case with Judge Washington. His sentencing is May 29th on that case. So he hopes that the bond will change at that time and that he'll be able to be released. So we're asking you to lower to something he'll be able to pay
So he's being held on a case before Judge Washington now.
until May 29th,
What's the proceeding on May 29th? Do we know?
sentencing.
Sentencing. What kind of case is that? Do we know?
I don't know, Your Honor.
All right. Response from the people?
Your Honor, we've asked the bond to stay the same. We think it's appropriate. He does have multiple pending cases at the same time. The case in 90 is a stolen case. This case has concerning elements of that. He's accused of child abuse, but also fleeing police and possessing a firearm. We believe he's both a danger and a flight risk.
So, let's break it down. Judge Simpson keeps control from start to finish. Mr. Washington gets another week to prove his progress, and Mr. Gatlin's plea to fire his lawyer falls flat. The judge stands firm on bond, refusing to lower it despite emotional appeals. It's a reminder that the courtroom isn't about emotion. It's about order, law, and evidence. If you found this case as intense as we did, make sure to hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, drama, and shocking moments every week. You won't want to miss what happens next in Judge Simpson's courtroom. Welcome back to the courtroom. And today's case is all about second chances, responsibility, and the razor-thin line between justified and excused. We're watching Randall Jolly, a Ford Motor Company employee, who's facing serious bond violation allegations after missing multiple court-ordered drug tests. His defense? A demanding job schedule, long commutes, and prescription, medication that might confuse the results. But when the judge begins pressing him for answers, and the prosecutor brings up old charges, this calm courtroom quickly turns into a pressure cooker. Stick around, because what happens next is a masterclass in accountability, emotion, and judicial control.
That the arraignment was happening, so I wasn't there, didn't know about it. I did review it this morning. The bond document in the file does not order my client to be subjected to testing. It tells him don't do drugs. Now, I don't plan to use that.
Well, but counsel, go ahead. You can.
I don't plan to use that as my
want, but go ahead.
Not a problem. Judge, the problem is really the past and going forward. He tested positive for a drug which is a opioid inhibitor. That, of course, is a drug you cannot get and you cannot take if you are taking opioids, because the combination of the two is likely to kill you. He has a prescription for that. So the funny sounding buprenorphine, yes, he has a prescription for that. He today can pull out of his pocket a copy of his pill bottle showing his prescription.
Well, he told me I was grabbing it out.
So, Judge, I have that available to the court.
He's on Suboxone.
He is.
Okay.
Yes, Judge.
Can I say?
Shh.
But you're saying he didn't know that he had the test?
No. That is not my argument. But Judge, going forward, I believe there's a problem. He has missed the last two tests. The only reason he missed the last two tests is he is employed full-time at Ford Motor Company. He has his employee badge in his pocket. If you can pull that out, we will offer that to the court. He works a crazy schedule. He builds cars, and he starts at 6 a.m. and he gets out at 5 o'clock at night. His testing facility closes at 4 o'clock at night. He's been there 5 years, but he doesn't have the sort of seniority to grant flexibility. So we apologize for missing it. So this morning, when I had no idea that there would be a bond.
What was the other drug, the amphetamine?
That was the initial time, Judge, and he's absolutely guilty of that. That was the first time he was ordered to test.
Yes.
Since then, he has not taken any of that stuff, and he will test negative today.
Well, there are two things. One, he had THC in his system.
Yes.
Whether he took it or not, he doesn't get a card till the next issued the next day.
Yes.
He also has abnormal creatinine, which is a problem because that usually will appear in rare circumstances, but typically when somebody's trying to mask.
So Judge, if I may, he absolutely flunked your first test, no question about it. But that was the first test, and since then, he has been clean. He missed the 2 tests.
I don't know how you say that. He took one other test.
Yes.
And then didn't test.
Yes.
That's.
Your Honor, may I say something? I'm sorry to interrupt. I just wanted to say something on my behalf.
Go ahead.
I live in Wayland. I work in Wayne. It's a 2-hour drive. I drive literally 4 hours a day back and forth to go to work and get back home. I work till 5 o'clock. I called my probation officer. I want to test. It's not that I'm trying to get away from testing. It's impossible when it's at a time I can't get there. And I don't want to lose my job because that's some benefits for the kids. I mean, it's a rock in a hard place situation. And I'm just trying to figure out the best way to move forward without losing.
Did you talk to your attorney about testing closer to where you are?
No, Judge, I had no idea there was a problem, but I will say this. When I found out this morning there was a problem, I called testing facilities.
Yes.
And I found places that have more relaxed hours. They also charge $130 to $150 for a test. At the moment, your court's charging them $12. And I mean, that is.
I don't mind paying the money. And it's the facility closed at 4. I just get off at 5. I have no issue testing, Your Honor. I really don't.
Well, when I look at this, you sit up here telling me you don't have an issue testing. I've got 2 missed tests.
Correct. I have an issue because of the time, Your Honor. That's it. I'm hands down. It's just because of the time. And I'm not trying to skate. It's hard. It really is hard to get out of my job. It's an assembly line, so they can.
I understand how.
I want to fix this. I do. I really do.
Well, and I don't know why somebody's not contacting the court or somebody prior to us getting to this point today. And when you know you haven't tested.
Sorry, Judge, I read the email this morning. I had no idea there was a problem.
And it would be one thing if all that was showing up in a system is Suboxone, but that's not everything that's showing up in a system from the initial test. And then I really don't have much for August.
I'm sorry, I didn't.
I don't have testing for August. I mean,
yes,
effectively, I don't have it. The whole month. He doesn't test.
I want to, Your Honor. I do. I just need a facility that's a little later. I'm just scared to lose my job. It's really, I got my kids. I mean, it's just hard.
Judge, had I known, I would have made efforts to try to resolve this before today. I had no idea this was coming.
I just need a little help.
Any response from the people?
Your Honor, I'm trying to sort it out. My concern stems from the fact that this offense date was July 2nd of 2024, where the defendant was arrested in possession of 56 pills of Adderall, which will show up in his.
This is the moment that shifts the courtroom's tone. The prosecutor brings up an older arrest, 56 Adderall pills found in Jolly's possession. And suddenly, his credibility takes a hit. Even though the current issue is mistesting, that history puts everything into question. From a legal standpoint, this highlights why pattern matters. Judges don't just look at a single missed test. They consider the context of past behavior. And when substances like amphetamines and masking agents show up in someone's record, trust becomes a serious issue. It's a powerful reminder that every court appearance carries the weight of the past. No matter how valid your reasons sound today, yesterday's choices can still come back to haunt you.
System as amphetamine. And when he was arraigned just this past month, he's given the opportunity to test to show that he was clean, and it shows that a year later he had that amphetamine in his system. Granted, it was right after he was released from custody, but without the ongoing testing, there's really no way to ensure the safety of himself or the public traveling back and forth so much on our roadways. If he's not clean, I have the same concerns that the board does, but can't add anything additional.
Anything else?
Judge, I wish there was an easy answer.
Your Honor.
If the court allows, he will spend $150 and test at a private clinic.
Could have done that
Yes,
before.
absolutely.
That's my point.
You're
My
exactly
point
correct.
is he could have done that before.
Yes.
There is nothing that prohibits him from doing that. What I have and what the prosecutors added is that the only test I have is that same drug that's showing up a year past is still showing up in his system. And then I don't have any testing. Simple as that.
You don't.
If it shows one, I really did. My probation officer, well, she'll tell you. Fine, you're sorry.
Court test him today.
I can't get him in because of time.
Well, he said by 4:30. Oh, sorry. Sorry, Your Honor, I'm sorry.
And find out if they can test him right now. If you come back dirty,
I won't.
I am putting you,
I have not taken none, I swear.
you know what? You need to be quiet about now. Can you see if they can get him tested?
Yeah.
He will test positive for the opioid blocker. Prescription, he takes it.
I understand that. Counsel, you probably should stop talking too.
I'm not good at that skill, Your Honor.
I know. No answer yet. You need to go over there, see if you can test. You
You
don't
shall.
get tested, you're gonna go.
So, Your Honor, may he take a sick day and test tomorrow morning first thing?
No,
Thank you, Judge.
I gave you your options. Go over there and test. If they let you in, fine. If not, you still gotta come back here.
Sir.
And if you don't test, you're going.
Thank you, Judge.
Bye.
Great. Sure, maybe for the people in your honor.
Your Honor, Mark Ellis representing Randall Jolly. Mr. Jolly, tell the judge your name.
Randall Jolly.
First thing that I'll do is I will adjourn the probable cause conference to the 18th, 2025, 9 o'clock. His test came back. He's positive for the marijuana. He did get a medical marijuana card the day after he first tested positive for marijuana. I'm going to suggest that you probably start or cease using that. But I have negatives on everything else. So what I will do is I'll continue his bond at this point with the admonition that if you miss another test, I'm not hearing argument, you're going. Simple. And then the other portion of that is that I will allow defendant may test. What county is that? if you live in.
Allegan. Allegan.
I'm a Michigan resident.
I'm sorry.
He may test in Allegan County at an approved facility by the community corrections.
I apologize, Your Honor, may I have the PCC date one more time?
Is the 18th.
Your Honor,
His test results, he must sign a release so that his test results are sent to community corrections.
Your Honor, if I may, first of all, thank you. I appreciate it. My condolences on this docket of yours today. Judge, in the interim, my client contacted his boss at work.
So what's the final verdict? Judge Ellis ultimately gives Jolly another chance, allowing him to continue testing at a nearby or approved facility, even at his workplace, as long as results go directly to the court. It's a fair yet firm decision, showing that accountability doesn't mean inflexibility, it means progress with conditions. This case proves how small communication gaps can spiral into major legal issues, and how transparency can sometimes save a defendant from jail time. If you found this case as compelling as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more shocking courtroom showdowns and real legal insights. Until next time, stay informed, stay curious, and always respect the court. Welcome back to the courtroom, and buckle up, because today's session is loaded with tension, confusion, and confrontation. We've got two defendants, two very different stories, and one judge trying to make sense of it all. First up, Floyd McFall, who stands accused of multiple violations involving alcohol and an alleged assault with, get this, a wine bottle. His lawyer pleads for leniency, but the prosecution isn't convinced. Then later, Megan Moses steps up, defending a tangled story about a faulty tether, a broken phone, and a desperate attempt to prove she's doing the right thing. Stick around. This one's going to test the court's patience, and your judgment too.
People have their witnesses available on the 9th.
Yes, Your Honor.
Preliminary examination in person, September 9th, 2025, 9 a.m. That's before
Judge Melville.
Judge Valvo. We've got, you want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Response from the people?
Your Honor, we have concerns about involved, like including, I would note that it's not just one incident, it's 2 different days. And that the report of the case when Mr. McFall was questioned about the August 19th date, he admitted drinking, but then we have an August 24th date. So
and also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those 2 on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down, he also then blew and numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
And so, Your Honor, part of the reason that we find it concerning, believe that alcohol related involved with this, and that as far as the felonious assault charge, the weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that a person would qualify with bond conditions that he seems to have violated them multiple times when he was confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really a substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He is here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was a no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
No. Just at my church, I don't have proof for it though, and I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Okay. Well, it looks like he is working on that, Your Honor. He's signed up.
Working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked, defendants remanded. Calls case of the people versus Megan Moses.
That's about some people.
Afternoon, Your Honor. Constable Bates on behalf of Ms. Megan Moses, who was present to my right. Can you state your full name for the record, Ms. Moses?
Megan Moses.
All right, go ahead.
Your Honor, today is the date and time set for probable cause conference. At this time, we're going to be asking for an adjournment to continue negotiations, as well as give my client some time to hopefully pay off some of the restitution in exchange for a better offer.
Before I set the date on an adjournment, she has a no bond warrant.
Yes, Your Honor. As to the violation, Your Honor, my client still has the tether on her leg. As to the explanation, Your Honor, she tells me she was riding her bike and the tether got caught in her bike and like with the pedal. So she kind of had to adjust it. She lives far away from community corrections. That's why she wasn't able to go in.
I have a broken phone too. I had my number to the tether guy in my phone and I had no way to contact.
So the tether came off in a pedal.
No, it's still on. It just pulled it and it.
Now this one's tricky. Megan claims her tether, the court-ordered ankle monitor, got caught in her bike pedal, causing it to malfunction. Add in a broken phone, no transport, and limited communication, and her story sounds like a logistical nightmare. But the judge seems skeptical. And so does the prosecutor, who catches her changing details mid-explanation. This is where courtroom credibility comes into play. When your story shifts, even slightly, it can erode trust fast. So was this truly bad luck? Or a cover-up for something more? Would you believe Megan if you were the judge? Let us know in the comments.
Like there's something poking through.
Did you call community corrections at any point?
That's what I'm saying. I was able to, I didn't know who to call except for the tether officer, Mr. Levitt, but it was saved in my phone.
Was your tether going off?
Broken. It was going off, but I was on my bike and I was kind of scared, so I wasn't sure where or what to do. I did call my mom right away. As soon as not call her, but I went to her work. I rode my bike to her work actually, and tried to use her phone, but I wasn't able to while she was using it for work. So
I didn't know where to call. What were you going to do with her phone?
I was going to call the public defender, which I did. I was able to email someone that following Monday because it was on a Friday, but I did text Hannah Mackey from the public defender that night when I was able to use her phone. Explaining that there was an issue and that I didn't have a way to contact. And then when I did finally get a hold of him and left a message out until tomorrow, I think, but I was waiting for someone to contact.
Did you go to the community corrections?
I called them. I did when I finally was able to figure out who to call when I got the email.
When did you call them?
I called.
How many days after this alarm went off?
Well, it happened on Friday, And then I got the number to call the community corrections that following Monday. I called and left a message for Mr. Levitt. I think I left the message actually today.
Your Honor, I just want to say that this is a tether was put on because I believe for a previous failure to appear, and she is here today, Your Honor. So it shows that she does want to comply with the court order. She does want to be here. She does want to handle her case.
But she doesn't want to comply. Have you been to community corrections at all?
No, I live in Jackson. I was lucky to get here today. I wasn't even sure what was going on. I don't have a vehicle or a phone at the moment, so I was requesting things through email as well, or trying to. I'm still charging it as well. Like, I'm not trying not to.
She's not trying to. She's not trying to abscond, Your Honor. She's not trying to disobey the court orders. It was just. It seems it was just an accident, and just due to her lack of efficient communication method, I think that's really where the problem lies.
I have an old tablet from 2015, I think, with Wi-Fi for communication right now.
And when I reached out to her and let her know that she would be required in person because she initially tried to attend via Zoom and put in a request via Zoom, she did her utmost to make it here, and she's here, Your Honor. So
yes, but I don't understand why she didn't.
She hasn't even secured a ride back yet today. So yeah. Her transportation.
But why she didn't keep in contact more with community corrections?
I think it's due to
this thing went off almost 10 days ago.
Well, I was waiting. I'm sorry.
Go ahead.
I apologize. I was waiting for someone to get back a hold of me through my mother's phone or through email because I wasn't sure, and I was still charging it. So I honestly just assumed everything was okay. I know that sounds stupid when I say that out loud, but I didn't know what else to do as far as contact. As soon as I found out the information this morning, I did everything I could to make sure to come and left another message on Mr. Levitt's voicemail, who will not be in until tomorrow.
The second page and what they suspect this defendant was doing is really alarming to me.
I'm not sure what that means.
Your Honor, I think that is mostly just speculation at this point. She still has the tether on. She's still been charging it. She's still.
What is?
And I don't think there's a hot zone to this tether, Your Honor. I think it's just a GPS tracking tether to make sure she comes back from court, is what I understood. And she is here today. So the purpose of the tether is being fulfilled.
Any response from the people?
Your Honor, when the court released this defendant in April of this year, the court gave her a chance. I had expressed concerns because she had 2 warrants out of Kent County, one for child support, one for an OWI 3rd, if I recall correctly. And I was worried about seeing her again. The court gave her this tether as to track her location. So it is the people's opinion that strict compliance with the tether would be a condition of bond. So any tampering, anything like that. I noticed when the defendant was giving her recitation of what happened, she first said, I called my mom, and then very quickly said, I went to her work. Because she earlier had said that her phone wasn't working. So that is concerning to the people. It's something I picked up on. I think the court picked up on it.
So what's the final verdict? Judge Ellis ultimately gives Jolly another chance, allowing him to continue testing at a nearby or approved facility, even at his workplace, as long as results go directly to the court. It's a fair yet firm decision, showing that accountability doesn't mean inflexibility. It means progress with conditions. This case proves how small communication gaps can spiral into major legal issues and how transparency can sometimes save a defendant from jail time. If you found this case as compelling as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more shocking courtroom showdowns and real legal insights. Until next time, stay informed, stay curious, and always respect the court. Welcome back to the courtroom. And trust me, this one's a roller coaster. Today, we meet Melissa Konowinski, a woman fighting for redemption after multiple DUIs, failed sobriety tests, and a shocking relapse just days after rehab. Her Attorney paints a picture of recovery and second chances, but the prosecution? They're not buying it. From emotional confessions to tense legal pushback, this hearing reveals just how fine the line is between accountability and compassion. Stick around, because the judge's final decision might leave you speechless.
Seen the bond violation report.
Yes, Your Honor, and we have discussed it, and I'm ready to address it when the court is ready.
Yes, I'm ready to address it.
Ms. Konowinski stated that she did drink, but it was only that one day. This was a one-day slip-up. She didn't take the test within 15 minutes because she fell back asleep. She takes mental health medications at night, which has been reported to CMH, which make her fall asleep. She wasn't avoiding calls. One of the numbers that she gave was her boyfriend's number, and he said that he didn't receive any calls. The other number no longer works. She did believe they have her current number, but that phone only worked on Wi-Fi, but she recently got it switched to a phone with a SIM card, so it now works all the time. This Saturday, the 30th, she returns to work at Dunkin' Donuts. On the 11th of September, she will start a part-time inventory job. She also receives her Vivitrol on the 11th. On September 22nd, she has an appointment for mental health addiction recovery and an evaluation with IHA Trinity Health. She has been going to AA and has proof. Her letters of recommendations from
How long has she been going to AA?
She has the proof. How long have you been going?
I've been going over a year. It's a sunshine group. But since I've been out of rehab, this is what I have.
When did you get out of rehab?
I got out on the 15th,
Of what?
August.
And she does acknowledge
And
that
started drinking by the 19th.
that was one day
One.
after. And since then, she has been testing negative. She has letters of recommendations from Bear River Health and one from her boss. She volunteered in Hanover, Michigan at Rust and Dust and has a letter from there also. She realized she slipped, and for the first time, she wants this court to know, she caught herself and immediately got back on track. And normally when she slips, she goes on a bender. Ms. Konowinski is asking for more time to test instead of twice a day so that she is more accountable to herself and to the court. We ask this court to recognize that she had no violations after that date and to give her another chance, especially since she has appointments set up for her mental health and for her addiction. She is also here today knowing that she could be remanded. She would also like to address this court.
Good morning, Your Honor. I first off want to thank you for back in December of evicting me from my ex's house. I'm glad that you did. I did not want it because that was a safe spot to drink. And since being evicted, things have changed. It's come into a lot in my life. I don't have to be in that household with him. And for that, I thank you very much. During the eviction, I was scared because I was giving up my way of drinking. And to this day, if I would have still been there with that man, I would probably be dead. So I thank you for giving me the eviction. And I do acknowledge and admit my part in this addiction and what I did. I'm not saying it was right, but I want to be fully honest with my recovery completely with sobriety because I don't have any more to give.
Response from the people.
This is an order July 3rd with 2 priors, both in 2021. This was a hit and run crash where the defendant was then located driving a vehicle with heavy front-end damage. She was so intoxicated they couldn't even do the field sobriety test. Eventually, her blood test showed she was a 0.280. I have no faith that she can be safe in the community right now. I'm extremely concerned that even with this gram header, given the levels that we see in the sober link testing, and I also know from the court, I'm sure the court's already seen it, it's towards the end of her testing window. So that leads me to have suspicion about what was it earlier in the day. I'm extremely concerned for public safety. Should she be released at all, I would ask that her bond be revoked and she be remanded. If the court is inclined to release her, I would absolutely request a scram tether. I don't think sober is going to be.
That moment right there, that's when everything shifts. The prosecutor just dropped the bomb. Melissa wasn't just drinking. She was behind the wheel during a hit and run with a blood alcohol level of 0.28. That's over 3 times the legal limit. You can feel the tension in the room rise as the judge weighs compassion against the community's safety. This isn't just a moral dilemma, it's a legal one. How far should a court go to give someone another chance when public safety is at stake? Comment below, because this debate hits hard for anyone who's ever believed in redemption.
What's your call me?
And Your Honor, I think she would be okay with that if she did ask for more times to test so that she could be more accountable to herself and to this court.
And I have to come back to that. I don't think more times to test is going to be an adequate solution here with somebody that's at a 0.28 crashes, runs from the scene and has 2 priors.
Let me clarify. I was saying that she would be okay with the scram tether.
He's currently in some type of program.
She starts her program on the 22nd.
IOP intensive outpatient.
IOP intensive outpatient,
When
September 22nd. She starts testing.
do I have that? Is it somewhere in writing?
I have it on that.
She emailed it to me. I can send it to the court.
Well, you can send it to the court along with some order. There's got to be some structure. If she's not going to be in an IOP, I can't take the chance that she's going to go on another one of these, hop into a vehicle, and this time take somebody out. I can't do that.
Well, Your Honor, she has been negative, and that was just the one day slip up.
Yeah, but that's all it's going to take.
I understand.
She's got, this is her third.
I don't have a vehicle.
She is,
Don't have a car. And I'm going to church and I'm doing AA and I volunteered. And I know what it looks like, but I wish people could see why I drink. To see the abuse and to see everything I went through. Why the hell I was living in.
ma'am, I get all of that. The problem is that what's going to happen outside of the alcohol, you could potentially end up killing yourself just from the alcohol. But then all it takes is one of these slip ups and somebody else goes, somebody who had nothing to do with any of that abuse, had nothing to do with anything. They're all of a sudden wrapped into your world and your tragedy that you've been suffering. I get it.
I understand that, but I haven't drove in over a year, 2 years. I'm willing to go with alcohol tether, and I'm fine with that, Your Honor.
And Your Honor, she now keeps in contact with me as a support system. She calls me weekly and we talk.
And I have like letters.
Got to put together something. I'll consider it next week in terms of programming or something like that that she's involved in.
Okay.
But
I do have IOP set up. I do have it set up with Medicaid rides and everything. I've been really working hard since I've been out to get back on my feet.
And there it is. The judge makes the call. Despite Melissa's emotional plea and promises of recovery, her bond is officially revoked. The risk was simply too high. What's striking here isn't just the outcome. It's the reality check this case delivers. Recovery isn't a straight line. And in the courtroom, accountability often outweighs intention. If you found this case as powerful and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more raw, real courtroom breakdowns that pull no punches. Until next time, stay sharp, stay curious, and stay tuned for more justice in action.